A sales contract or a lease contract are special types of contracts governed by Article 2 and Article 2A. Article 2 and 2A, they contain the common law as the general contract principles. Remember those common law contract principles? If you need refreshing, check out the chapters in the book. But there are some differences, the offer, acceptance, consideration. We talked about that in ACC 351. The importance of those terms. They are all required. They're still required in a contract involving a sale of goods or a lease of goods. We still need this offer, acceptance, and consideration. But there are some unique differences. The UCC does change some of these. So let's talk about those changes. First, just like common law contracts, the parties are free to establish whatever terms they want in a contract. We use the UCC when the parties have left out a term or when they've left out a term and those left out terms or those omissions are now causing problems. So let's talk about the offer. We know that under general contract law, a contract's formed when we have a definite offer, one that's been made and it meets with an unqualified acceptance. So let's take, you offer to mow my lawn twice a week for 4 weeks, and I say, great, I agree. Do we have a contract? This would fall under the common law. We're missing something, aren't we? The price? How much? How much am I going to pay for you to mow the lawn? This would fail. This contract would fail under the common law. Under the UCC, sales contracts, they will not fail for indefiniteness, even if one or more of the terms are left open, as long as it can be shown that the parties intended to make a contract and there is some reasonably certain basis for a court to grant an appropriate remedy. So if the party leaves out the price or the contract allows a party to determine the price at a later time, or maybe a third party can determine the price if that's what they've decided in their contract, and now a problem arises and there's no price indicated in the contract, a court can set what's reasonable, right? That's an appropriate remedy. They can set what's a reasonable price. How would they do that? They look at the market value. They might look at the industry that we're talking about to see what is appropriate and fair. So that's what the court would do if there was an open price term relative to a sale of goods. So what about this? I'm going to sell you widgets and you agree to buy widgets from me. This is probably going to fail, not because we don't have a price, because remember, we're looking at, the court can reasonably set a price. Well, they'll look at the market value of widgets, but what are they going to base it on, right? We don't know the amount, right? An open term here is the goods. We got widgets, but we don't know how many widgets. So can that be fixed? Can a court say, you know what, you're going to buy 100,000 widgets. Oh, and the fair market price of that is X, right? So you must have, at a minimum, the quantity of goods involved. You need the quantity of goods. They have to be expressly stated. If it's left out, there's going to be no basis for determining a remedy. All other instances, delivery time, mode of delivery, those terms can be determined by what's reasonable. Like I said, what does the court use to determine reasonableness? Market value, other comparable sales, standards in the industry, all of those things. The one thing the court can't do reasonably is tell you which widgets to buy and sell. So you must need the quantity of goods. So these are our rules regarding offer under the UCC. Open price, court's going to fix what's reasonable. Reasonable price at the time of delivery of the goods. So it's really going to be dependent on what kind of goods we're talking about. Are we talking about widgets? Or are we talking about eggs? Right? So the court will determine what's reasonable. Quantity must be expressed. All other instances are going to be determined by what is reasonable. What if the contract for a sale of goods leaves it to one of the parties to specify one of the open terms, the particular means of performing, the price, the time, the delivery? We call it an open term. And what if it's to be determined by Mr. A? Is that okay? Will it invalidate the contract? Parties can agree to leave that determination of a specific term to a specific party as long as any such specification must be made in good faith and within limits set by commercial reasonableness. So, for example, we make an agreement whereby you purchase 100,000 widgets from me for $200,000. The contract provides that you state when and how you want them delivered. So under the UCC, when you provide how you want them delivered, you must make that request, or you must have to ask in good faith and with commercial reasonableness your mode of delivery. So you can't come back and say, hey, I want my 100,000 widgets, and oh, by the way, can you ship them by, I don't know, Amish buggy, right? Or horseback, or carry them one by one, right? That would be unreasonable. So commercial standard, maybe that's tractor trailer, maybe that's by train. So it must be made in good faith and with commercial reasonableness. So let's talk about our merchant. The UCC, like I said, will state specifically in the code and in the law about whether or not you're dealing with a merchant. And merchants can make offers. And we call a merchant firm offer is an offer by a merchant that is irrevocable without consideration for a period of time. The firm offer must be in writing and signed by the merchant offerer. If no time period is stated, no longer than 3 months. I do want to point out that the person doing the accepting or the offeree does not need to be a merchant. It's the one who's making the offer. If you remember from common law, we can't do this. We can't say, hey, I'm going to leave my offer open. I promise to leave my offer open for 3 weeks. And then they take it back in 2. That's not enforceable because you need consideration to do that under the common law. But here, if a merchant's doing it, it needs those items in place for it to be held open for that period of time. So the UCC has this exception to the rule only as it applies to merchants. So an offer can be revoked at any time unless offerer is a merchant and the offer not to revoke is made in writing, signed, and with a specified period. If no specified period, no longer than 3 months. So let's take this example. We have Sam, who's a used car dealer, offers to sell a certain 2000 Chevy to Beth for $1,000. She tells him that she can't make up her mind right now. Sam says to her, don't worry, I'll keep the offer open for the next week. You can accept any time until then. The very next day, Beth decides to buy the car, but before she can get over to Sam's, she receives a message from him on her telephone answering machine in which he says that he decided not to sell the car to her at that price. His message concludes, I would sell it at $1,200. And my question would be, can Beth get the car for $1,000? And the answer is no. Why not? Even though we have a merchant, Sam, the used car dealer, would be considered a merchant. We don't have it in writing, right? It has to be in writing. Suppose that at their initial meeting, Sam had scribbled on a memo pad bearing his company's logo the following, quote, offer to sell 2000 Chevy to Beth for $1,000. Good for 1 week as of today, end quote. The only other marking on the piece of paper was the day's date. Would that change the answer? Can she get the car for $1,000? And the answer would be no, because he didn't sign it, right? Needs a signature on it. How about Bonnie? A bank president drives her into Sam's looking to sell it. She's asking $2,400. Sam says he'll consider this deal, but only if she signs a piece of paper he writes out that says Bonnie offers to sell her car to Sam for $2,400. This offer to remain open and irrevocable for a period of 1 month from today's date. Sam dates the paper and asks Bonnie to sign it. Is Bonnie bound by this offer? And the answer is no. The answer is no here. Why not? Because Bonnie is not a merchant. Bonnie's just, her job is a bank president. She drives her car and she's looking to sell her car to Sam. So the point being the distinction between merchant and a non-merchant. But if Bonnie herself is a dealer of automobiles and that happens, she's not the banker, and she goes in to sell her car and Sam writes that out and she signs it, yes, she would then be bound to keep that open for a period of 1 month. That's how the merchant firm offer works. Now let's talk about acceptance and the differences between the common law and the UCC. Where the offer doesn't specify the means of acceptance, the UCC provides that acceptance can be made by any means of communication reasonable under the circumstances. So the offer still controls. The offer says how acceptance needs to be made. That's how it has to be made. If it doesn't, then the UCC will provide that acceptance can be made by any means of communication reasonable under the circumstances. So the UCC permits acceptance to an offer to buy goods for current or prompt shipment, either by a promise to ship or by prompt shipping of the goods. For example, I send you an email offering to buy 1,000 widgets from you at your cheapest rate. How can you accept this? One of two ways, right? Yeah, I don't say how to accept it, so what would be reasonable? You respond back to my email saying I accept, or under the UCC, you can ship those goods to me. By prompt shipping the goods to me, you have accepted. You don't even have to respond. They're on their way. You don't have to. You just prompt shipment or respond back by a written communication or an email communication. You could probably even pick up the phone and call and say, I accept. I'll send them out tomorrow. What if the seller does not promise to ship the goods? Say you didn't respond to the email, right? You don't promise to ship to the goods that the buyer ordered, but instead you ship goods. But when you ship the goods, you ship goods that are different from what the buyer has ordered in some way. Maybe they're a different size or color, like the example here. Macintosh orders 5,000 red headphones from Hayden. Hayden ships 5,000 black headphones that he has in stock. Hayden doesn't tell Macintosh. Do we have acceptance here? Under the UCC, yes, prompt shipment of goods constitutes an acceptance. However, didn't send the right color. So technically there's a breach of this contract, and Macintosh does not have to accept them. What if Hayden tells Macintosh that he shipped black? So he sends out the black ones and then sends an email. I shipped you black, and they're being offered as an accommodation or a favor. Now this shipment of the goods constitutes an offer, and the contract will be formed when Macintosh decides they're going to accept. To compare to the common law, under the common law, if the acceptance differs from the offer, it is a counteroffer. There's no contract that's formed until it's accepted. So if you send me a letter offering to sell me your bike for $100 and I write back I accept, but paint it blue and deliver it to my house, we might not have acceptance here. I can't change your offer. All right, so the concept under the common law is considered the mirror image rule. So every business has forms, right? People in business, they tend to rely heavily on forms and documents that they have created or pre-printed for their own use. They detail all manners of terms and conditions that do not surprisingly suit everybody, right? So if each party insists on their form, you can use my form. Nope, I use my form. What do we do? What do we have? So to avoid these problems, the UCC dispensed with the concept or the idea of the mirror image rule. when we're dealing with forms. Under the UCC, a contract is formed if the offeree makes a definite expression of acceptance, even though the terms of the acceptance modify or add to the terms of the original offer. What happens to the new terms depends on whether we're dealing with a non-merchant or we're dealing with merchants. So everybody can use their forms. How the new additional terms or modification terms apply to our agreement is going to differ. So let's talk about those two differing rules. So the first rule, when one or both parties are non-merchants, the contract is formed according to the terms of the original offer submitted by the original offerer and not according to the additional terms of the acceptance. So mirror image rule applies here. It doesn't differ at all. So I purchase 500 books on the UCC from an online retailer, Books Plus in Michigan. When the books arrive, the accompanying invoice includes an additional term that states any dispute between the parties will be settled in Michigan. When a dispute arises regarding the payment, Books Plus files a suit in Michigan. The question is, am I bound by that dispute resolution clause? No, because I am not a merchant. The second rule, when both parties are merchants, the additional terms become part of the contract unless, first, the original offer expressly required acceptance of its terms. So any new terms would require written consent or any sort of consent. Number two, the new or changed terms materially alter the contract. So if the initial offer was buy 100,000 widgets for $300,000, but the acceptance says buy 100,000 widgets for $200,000 or whatever. Those are material contract terms. Can't alter those. But number three, the offerer rejects the new or changed terms within a reasonable time. So I offer to buy 100,000 widgets for $200,000 to be shipped in a month, and the acceptance says we'll ship in 1 week, and the offer says no way, I can't do that in a week. Well, then we have proper rejection. If the offer says nothing to that, they're going to show up in a week. The last component, consideration. Contracts must have consideration, even under the UCC. However, the difference becomes when we modify the contract. When it comes to modifying the contracts, the difference under the UCC, for the common law, modifications to an already valid contract must have additional consideration. Must have additional consideration. Under the UCC, we don't need that. We need good faith. And we've defined good faith as honesty and observation of reasonable commercial standards of fair dealings in the trade. That's the language right from the UCC. You need good faith, and good faith is defined as honesty and observation of reasonable commercial standards of fair dealings in the trade. You agree to sell me your bike for $100. I agree. We agree that in 2 days you will deliver the bike and I'll pay you $100. The next day you call me up because you learned the value of your bike is $500 and you now want $500 for the bike. I agree to pay you $500. The following day you show up with the bike and I give you $100. Do I have to pay the other $400? And the questions are, does this agreement fall under Article 2? Yes. This is a sale of goods. We don't need merchants. We're two people. Somebody's got a good that's being sold, and you're using the other party's got cash to pay the price. Do I have to pay the other $400 is the next question. Good faith? Is this good faith? This arrangement, this modification, because we don't have consideration. Right, we don't have consideration. The initial agreement, the pre-existing duty, was to sell me the bike for $100. Is what happening here in good faith? The answer is no. No, this is extortion, right? This there's no good faith here. There's no reason why. You should have determined what the value of your bike was before you offered to sell it for $100. So, do you have to sell the bike? Yes. You have to sell the bike for $100. Jim agrees to manufacture and lease certain goods to Louis for a stated price. Subsequently, a sudden shift in the market makes it difficult for Jim to lease the items to Louis at the agreed upon price without suffering a loss. Jim tells Louis of the situation. Louis agrees to pay an additional sum for leasing the goods. And the question is, does Article 2 govern? Well, actually, it should be governed 2A. Article 2A would govern. Does the UCC govern this transaction? Yes, it's for lease of goods. Can the modification happen? There's no consideration here, right? But the reason being is there's the shift in the marketplace. Is that a good faith reason to modify the contract? Probably so. Probably so.